a question, Mr. Joshi, because I think we could also believe that Congress was really interested in making sure that safety was top of mind, priority. And the problem, I think, with the argument and the way that you've set it up is that you are assuming away any responsibility that a broker might have for safety. Your argument depends, in a way, on us accepting what you've said, what Mr. Boutros said, that brokers are just operating as middlemen. They really don't have anything to do with safety. And I guess I don't understand why we have to believe that Congress shared that view, as opposed to Congress thinking, well, to the extent that brokers are involved in safety, that's going to come out in the tort suit as a causation issue. And so we don't really have to take a position on which individual defendants are actually responsible for safety. What we want to do is make sure that safety regulations are preserved, that safety is top of mind for everyone, and if brokers really are the kinds of middlemen that Mr. Boutros and you say, they're ultimately not going to be held liable, because either the state's not going to allow this kind of tort suit on the front end, or they're not going to be held liable because they're really not a big player in this from the standpoint of tort law. Why can't that, to me, is perfectly consistent with the view that petitioners have and make your view seem a little odd?
So two responses to that. Well, first, I agree. What you just said is consistent with what Mr. Clement says, but obviously I disagree with it. So a couple of statutory points that I think show that Congress, in fact, was thinking that brokers wouldn't be responsible for safety. So they did share the view that Mr. Boutros and I are advancing today. Number one, on the safety exception, it would have been the easiest thing in the world for Congress to just repeat with respect to transportation, just like it had half a sentence earlier, or just leave it out entirely.
But wouldn't the easier thing to be to say something about brokers in the safety exception? I mean, if you're right and they shared this view that there were certain individuals in the chain who are just not going to fit, then I would think we would see that language in the safety exception, right?
Sure, Congress could always be more clear, but what I'm saying is that Congress's choice there suggests that they did not necessarily view it this way, but there's more. There's much more. Congress has an entire several chapters of the U.S. Code in Title 49 that deal with safety, addressing carriers, safety of motor vehicles, driver qualifications, and they're all addressed at carriers. Not a single one is addressed at brokers. And I'm going to now invoke, they say the exception sometimes proves the rule. In 2012, Congress passed a statute, and they added a provision, and that provision makes transportation intermediaries, which I think we all agree includes brokers and freight forwarders, liable, and it says, you should not coerce a driver or a carrier to violate all these numerous safety rules that apply only to carriers and drivers.
As a matter of federal law.
As a matter of federal law.
Right.
And so it's a little bit odd.
No, but what I'm saying is this statute expressly preserves the scope of state safety regulations. So it's no answer, I think, to point out that Congress under federal law would not have held these brokers liable. The question is, what were they doing when they said, here, we are preserving state ability?
Right. No. I took your original question to be, why do we think Congress shared the view that brokers would not be responsible for safety? And what I'm saying is the entire federal scheme is set up so that carriers and drivers who, to use tort law terms, are the lowest cost avoider in terms of safety, are responsible for safety, and they have to pledge that they're responsible for safety and obey all the safety rules as a condition of federal registration. And then brokers select from the pool of registered carriers.